Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
Whether or not a true, that is not my focus. But I may focus in this as the voice for the voiceless. It's better say make us a grassroots than you juma. Sing crofwa, Oman Wajon, Dramani Mahama. Now you didn't appointment. In fact, so I'm telling you, Ghana for you can be father for all for what you care. Baby is so cry, or make us 1 year. Then your people, say bia, would do any show mono. Now I'm Daniel here for good baby. I am here to make sure say the government will do what is right. To make sure so because when your opportunity before Ghanaians. Because at the end, omwa ete pentekwa no mo na besi adimachi in the 2028 elections. Omuni di me ya obi entimi di me. Finito. Kwame, take me to Parliament. Now enter the ruling of the Speaker of Parliament. Right Honorable Sumana Alban Bagwen on the Honorable Nyindam case of like following the Tamale High Court ruling said there were some electoral irregularities caused in the 2024 elections or Pandai to be specific.
Layer that may prevent changes to the member status within the meaning of Article 97 and 99 of the Constitution. The House's attention is also brought to Article 105 of the 1992 Constitution, which provides that a person who sits or votes in Parliament, and I quote, knowing or having reasonable grounds for knowing, unquote, that he is not entitled to do so commits an offense. It is crucial to emphasize that Article 105 is penal in nature should the member know that he ought not to be in the chamber and he participates in the activities in the chamber. Honorable members, it's therefore too much premature to say that the Honorable Matthew Nyindam is disqualified from entering and participating in the proceedings of the House, because this period still falls within the 7 days mandatory stay of execution of the order. Honorable members, this is not a declaratory order. It is an executive order that was delivered by the High Court. And so the honorable member is right to have been in the House yesterday and to have participated in the proceedings. Honorable members, as I indicated, I had a second job to do, and that had to do with the ruling. The ruling is in respect of the complaint of contempt that was brought against the minority leader, Honorable Osahin Alexander Kwamina Afenyo Markin, member for Efutu and minority leader of the House. Honorable members, on Tuesday, 11th November 2025, this House received a formal complaint under Order 6 and 33 from Honorable Mahama Ayarga, Member of Parliament for Boko Central and Majority Leader. The complaint alleges that Honorable Osahin Alexander Kwamina Afenyo Markin, Member for Efutu and Minority Leader, has engaged in conduct which, if substantiated, may constitute contempt of Parliament and a breach of parliamentary privilege pursuant to Orders 30 and 31-0 of our standing orders. The complaint arises from events said to have occurred during the sitting of the ECOWAS Parliament in Port Harcourt, River State, Nigeria, from 25th to 28th September 2025. According to Honorable Ayarga, Honorable Afenyo Markin attended that session of the ECOWAS Parliament in contravention of a duly adopted resolution of this House, which excluded his name from Ghana's delegation to that regional parliament. The complainant asserts further that this conduct amounts to an affront to the authority and dignity of Parliament, and accordingly invites the Speaker to refer the matter to the Committee on Privileges and Immunities for inquiry and recommendation to the House. Honorable members, as I indicated at the close of the Majority Leader's submission that day, the standing orders prescribed the procedure to be followed when allegations of contempt or breach of privilege are raised. It falls to the Speaker in the first instance to determine whether the facts disclosed in the complaint established a prima facie case warranting referral to the committee. Members recall that I deferred my ruling to the next day, and that was to be Wednesday, 12 November 2025. However, the pressures of business on the order paper made it impossible to deliver the ruling on that day. I am now in a position to do so. In considering this matter, I have reflected carefully on the facts alleged, the standing orders, and the relevant constitutional and statutory provisions governing 1, the authority of Parliament, 2, the binding force of parliamentary resolutions, and 3, the scope of Parliament's contempt jurisdiction. What is the nature and effect of a resolution of Parliament? Honorable members, a resolution of Parliament is a formal act through which the House expresses its collective will on a matter properly before it. Once adopted, a resolution becomes a binding decision of the House until it is rescinded, suspended, or varied in accordance with the standing orders of the House. A resolution, therefore, has continuing effect, and the Speaker, as the presiding authority, is bound to give effect to it. While the Speaker may clarify the scope or meaning of a resolution, he cannot amend, modify, or disregard it unilaterally. Honorable members, this principle reflects the doctrine of collective responsibility. When Parliament speaks through a resolution, that decision binds all members, irrespective of political affiliation, leadership status, or personal opinion. As Eskime reminds us, and I quote Eskime, the dignity of Parliament depends upon the observation of its rules, and the authority of Parliament depends upon their enforcement, unquote. This is the foundation upon which parliamentary collective responsibility rests. So what is the power and scope of Parliament's contempt jurisdiction? Contempt of Parliament refers to any act or omission that obstructs, impedes, or undermines Parliament in the performance of its functions, or which affronts its dignity, or tends either directly or indirectly to obstruct, impede, undermine Parliament in the performance of its functions, or affront the dignity of Parliament. Parliament's power to address contempt is inherent in its constitutional status as a coordinate arm of government and is expressly recognized under Article 122 of the Constitution, Order 30 of the Standing Orders, and Section 26 of the Parliament Act 1965, Act 300. Honorable members, the jurisdiction to sanction contempt is not limited to acts committed within the chamber. The relevant test is whether the conduct, wherever it occurs, has a direct or indirect tendency to obstruct, diminish, or bring Parliament into disrepute or ridicule. Parliament may therefore exercise its contempt jurisdiction over conduct occurring outside the presence of the House, where such conduct undermines the institution's authority or impairs its ability to give effect to its decisions. Honorable members, I note that the specific instances of contempt listed in the standing orders, such as disorderly behavior, deceit, or disobedience of an order issued by the presiding officer, do not expressly identify non-compliance with or disregard of a resolution as a distinct ground of contempt. A resolution, as earlier observed, is a decision of Parliament, not an order of the Speaker. There is therefore no express provision making its breach a stand-alone category of contempt. However, Section 26 of Act 300 makes clear that the enumeration of contempt grounds is not exhaustive. Parliament retains the right to treat as contempt any act that impedes its functions or affronts its dignity. Order 31A similarly contemplates conduct, whether specific or general, that brings Parliament into disrepute or undermines its institutional authority. It is within this broader category that the present allegation must be assessed. Honorable members, it is useful to consider what constitutes an affront to the dignity or authority of Parliament. Orders 30C and 31 prove directly or indirectly brings Parliament into disrepute or which undermines its authority, reputation, or dignity may amount to contempt. These capture behavior that, while not obstructing proceedings, undermines Parliament's standing, coherence, or credibility. An affront to the dignity or authority of Parliament may arise where a member's conduct A. challenges or disregards a valid act or decision of the House. B. diminishes the institutional authority of Parliament or the Speaker. C. undermines public confidence in the discipline, unity, or dignity of Parliament. Or D. brings Parliament into disrepute before state organs or external bodies. Unlike other specific grounds of contempt set out in the standing orders, this category focuses not on the place where the act occurred, but on its effect. Conduct that conveys the impression that Parliament's decision may be ignored without consequence qualify as an affront to dignity, even if committed outside the presence of the House. Democratic experience across the world teaches that institutions endure not by their formal design alone, but by the conduct of those entrusted with them. The strength of this House, therefore, rests not merely in its constitutional design, but in the consistent respect members accord to its decisions and processes. Honorable members, having reviewed the complaint, the standing orders, and the governing principles, I am satisfied that the matter raised prima facie implicates the dignity and institutional integrity of this House. Pursuant to Order 34.1, I therefore refer the matter, the complaint lodged by the Honourable Member for Boko Central and a majority leader to the Committee on Privileges and Immunities for examination, inquiry, investigation, and report to the House. The committee is directed to 1. Ascertain the relevant facts giving rise to the complaint, including the actions taken by the House and by the Honourable Member concerned. 2. Review those actions taken within the framework of our standing orders and the applicable protocols of the ECOWAS Parliament. 3. Determine whether the conduct, if established, constitutes contempt of Parliament or a breach of privilege under Orders 30 and 31. And 4.
Honorable Afenyo Markin, of course, Obekaya, Honorable Dafiama Pomonim Penufubiaka, Ebeka say, Honorable Nindam, it's answered Tamale High Court. Like I said, there were some electoral irregularities in Tiensan Koto Abanfo from. That is, we know who can say, but no be participate in proceedings in Parliament. In T or Quambisono, there is uncle free. Omuyino a free mukrakra. Speaker Caswad ruling beba. Na OT speaker. Na chese inquiry say near maybe biguna kwansono. Because wow ho we say on the tour. That was the first ruling. Now the second ruling no. Obeka say a year Honorable Afenyo Markin. I can not ECOWAS Parliament. Ama maybe dria omuyini free ECOWAS Parliament was replaced. Intine enye say oko ECOWAS Parliament one. Abra ye she afufo na se no na ye gi ana ye ratify omo aka ni na member countries ni na Ghana for parliamentarians representing Ghana koya, they were not ratified. Yanjoma ntum yentimi answa yentimi anso in adentia Honorable Afenyo Markin so aba na je se obi komu na je se nipa mienu ana aba for one position eba ne sa no yentimi answa na je se edenim guase aba ama omo san do manim nsansa sa eba Ghana high. And on a majority leader, Mubekaya o raise kwam said, there be Afenyo Markin. Yanyanisa. When this was swan, who feel at the better a potro, the niso sound. Don't mean fat when you want to win a potro. Yanyanisa, a sentinel, or catch them, Mr. Speaker, say, Uncle unruly on any amahon dear, a year honorable Afenyo Markin. A year. Speaker deferred his ruling, I say, I'm a permanent. What in ruling member speaker say and of course I'm say o hwe ne no a e course no a e yade a antwa yi ntin komobom no na che say at the Parliament anyonyam kura e ba form mbaka se Ghana kura monye organized because no less a person than minority leader of the biggest opposition party in Ghana, knowing very well, and again Papa or a lawyer, and I'll be linking him to and some more Kanye Efre the Tamale court and judge kangaroo court, and I'm like, wow, like seriously, into while refer matter no to the privileges committee. Wamu ana beshe no omaka sasem. My main kase Honorable Samson Asaka Wingobet adjoining Samsona Abdul Manaf Rabiu and so ewa yebekum na yedi enkomo, but fameko near Honorable Afenyo.
The judiciary must know that their actions and inactions to serve the interests of whoever their paymaster is has the tendency of destroying our peaceful republic. We will not mince words. They can conspire to call us one by one for a so-called contempt of courts. We are criticizing their shameful conduct. We are not afraid. We are ready to be in Nsawam for their so-called contempt. The world will see their disgraceful conduct. We will not sit aloof and allow them to undermine the very rule of law that they are supposed to protect. How can a judge who calls himself a judge sit in court and misconduct himself in such a manner and expect the country to be quiet? Now here is where the matter becomes even more extraordinary. This order, an order with massive political, legal and democratic consequences, was pronounced without the court's full judgments, as I've stated supra. There were no written reasons, no factual findings, no legal analysis, just a naked directive issued into the public domain. And the whole constituency is now being told that there must be a rerun. I am a practicing lawyer of experience at the bar. I understand that courts occasionally deliver rulings with reasons to follow. But such a practice is the exception, not the rule. And it is never an acceptable approach when the stakes are this high. The judiciary must know that their actions and inactions to serve the interests of whoever their paymaster is has the tendency of destroying our peaceful republic. We will not mince words. They can conspire to call us one by one for a so-called contempt of courts. We are criticizing their shameful conduct. We are not afraid. We are ready to be in Nsawam for their so-called contempt. The world will see their disgraceful conduct. We will not sit aloof and allow them to undermine the very rule of law that they are supposed to protect. How can a judge who calls himself a judge sit in court and misconduct himself in such a manner and expect...
Because, say, as experienced person at the bar, now also contempt is so called. And you see, I am waiting for that day. I mean, so man no be against any court to be children some who be abreme. I'm also waiting. Now court to be entrance him who be mbreme say me they watch me contempt because me ma can say metia. Na ma bo honorable Afenyo tape ya tell say is he a superhuman being? I'm just waiting. I'm just imagining say any other person say me to Darko kwabra bi ansa and any of the soldiers I crowd say Ghana be fan into my pefra ana can same be singer anka court be send bail biana muhunu say this is recorded in history na muhunu say sensem ye atwagui as a court nyina da e okrom hai so obi su koka sensem no a court no nkoso na because mama ye hunu say bibia no ever contempt of court. Parliament. Odo sabe nkum kire parliament a yes be the contempt of parliament. Anameboa. Be the contempt of parliament. Parliament. Where honorable Afenyo is coming from, be the contempt of parliament. And as a legal luminary with so much experience like you claim, now you make such reckless statement. It is funny the kind of a country you build like an animal farm. Would you anywhere pass so when your authority be when you do be scapegoat, your authority no timi can say no fan where that is the kind of a country I team and I don't know say if so sad spectacle. Now question that me be say since when the honorable Afenyo Markin who say Ghana court a kangaroo court since when? Hey, since when? That's a bafu bunny court. A kangaroo court there. What do you call Tokonus court? May say, Sir Chief Justice Bafu Bunny. Ne court a kangaroo court. What do you call Mame Araba Tokonus Court? And nobody or tree court and I'm not surprised Honorable Afenyo is crying foul because Chief Justice Bia or the Assembly Court within 2 hours obey panel judges amano on your view. That kind of sinful act is gone. It's gone. Now there's a resetting agenda and yansa fuaba. Tomo ye neme nyansam. And yansa fo ne abu maino. E jimi fo ni hobio. That kind of enkrofonu and kamubenya they just empan. You will not get it again. So I'm not surprised to say you throwing your weight about. Now when they are court, Montana. Now mon train so be no bepa, move flow to that. Make them say there is no contempt of court. Because the Afenyo kind, if you fail to act, then there's nothing like contempt of court. Minority leader Afenyo Markin cited for contempt and referred to privileges committee. Where you're different, where has to do with Yakasimon Kwekowas parliament. Anna or Kwekowas parliament, ye unifrim, and also one Tiasi no Koi. A Tomoko and Ghanaian delegation, they were not able to be ratified. And I'm doing and the speaker has referred him to the privileges committee. But I'm talking about proper contempt of court. As seven hour cannot was it so called that one from Munjari. And I'm now when I know was added my mouth of what body am I about for some conference in Munabasemen? What are you talking about? Please, this is a serious country. It's not a banana republic. And I keep saying, No, man for Nebia may come anyone hand my hook and me here. But it's so sad, sir. Say, if you to me can some be on bosso, they get away with it. Huh? Oh, a crown for and you be a play bag, you know. Huh? A crown for systems. On person with yawa, no the play bag. Don't send this in so bad, as a play by a dean almost because Jamie will beat him so and also obey the chronos are no dear 1519 chronos are. Because say no bitrim so no so being na obetuaka. What is the use of a plea bargain as a law? What's the use? What's the use of a plea bargain? Chronophobia could be a Ghana $100 million. I could invest in your son for so. What's why I ready so better mine? No matter says cano. Now fast one what could Obiko trouble there. Also on the man who trouble in Shemas plea bargain. What kind of nonsense law is that? Yes, it's say. And let me say this 2 minutes. Name Ramadin Kobabushavo. I pray, say, and I'm speaking to one Mary Boudua. Let me put it in a bracket of allegations because media me who in the green letter. But to be forewarned is to be forearmed. And I know what it means to be in power and what it means to be in opposition. It is a when you're to me, you guard it jealously. And people and to be in power, but it's too late. And that is why, ladies and gentlemen, and this if one was a siano, yena yam pemboneno, ye tumufu kasemutie. There are times, mo ye campaign, mo girlfriends, ya two about we are finer, mo girlfriends, now who some here appointment. And the boys that worked, they'll be neglected. Where you no kura ya catch them where where no kura catch them mama appointments na my chair, but we tell you the truth to stay in power than to lie to you or tell you nyama mama mutrima ya mude and you lose power. Sana lady ya wo free wo no wo baamia say ne assistant to say then a free party num 2 weeks was so about joining NDC pa ya the senior presidential staffer ye tumu famunti o ye tumu famunti Ghana who been a na no to dako. And Ghana who been a nanama nanama yeah nanama is so on your TV. Ghana who been a yatiti ya cannot crash them one moment say bia ya isabia bubu. No, we want you to stay in power. Musha grassroots there before because in the first place a lot of the grassroots you are not taking care of those guys. They be making the likes of Sami Jenfi, Julius Dabramu, Tamaklo, Mami Owo, Mahamake. The pocket of them and yes, Sankrophobia, like they cannot put body and soul together. Communicators, a court radio, Suko TV, so have we taken care of them? I am praying, say, sir, Marie, what they say, Maria, Buedu, I'm not a young cresse, Yaman, and I'm telling you why I'm a buefu. Maybe you don't know why. I may pursue about tape with mammy. I know my way, no,
I'm out. We will retire John Mahama. NDC as a political party. I'm sorry, I'm out. To my membership card, I'm no longer a member of the NDC. Enough is enough. May I am joining you? May I send them a hunko? We will retire John Mahama. NDC as a political party. I'm sorry, I'm out. To my membership card, I'm no longer a member of the NDC. Enough is enough. May I am joining you? May I send them a hunko? We will retire John Mahama. NDC as a political party. I'm sorry, I'm out. To my membership card, I'm no longer a member of the NDC. Enough is enough. May I am joining you? May I send them a hunko? We will retire John Mahama. NDC as a political party. I'm sorry, I'm out. To my membership card, I'm no longer a member of the NDC. Enough is enough. May I am joining you? May I send them a hunko?
Was it one of them? One of them, may MC for one of the NDC programs. Huh? Me MC for one, I think so. And when I was saying no financial kufadon. Oh no, I think that's what she said. Where? What I say? Oh no, say no. And a little kuku to sometimes, anyway. Let me fancy her. But I'm telling you this for free. It's better I tell you the truth. Emma Wunya would but a bit wow, Darchi. Since I make trying to remember why you're there as your praise singer, but a bit how Darchi. Jay, a cocoa such like Romanian Feda. NDC, learn how to take care of your own. Because in times of trouble, it will be your own that will rise to your defense. Tie, in some American, learn how to take care of your own. I won't go bit money. Those guys, Atudazimu, PPP guy, meaning what they saying. Oh, that being Solomon Usu, fantastic man, Solomon Usu. Oh, PPP, Divine Kruma. Those guys may not directly be NDC, but I tell you what they brought to NDC, you have no idea. Yamfan say no correct. O de mi hu green letter bia. Yamfan say no correct. But this is just an advice. And your dawn or no can correct them. Mo pambeti me Jubilee House. Mo pambeti me asre. I am telling you the truth as this. Boys, ni girls, a two abama monua, or more polling station, branch executive, constituency executives, no. May catch them go take care of them. They are the same people you will need in the 2028 election. A word to the wise is in a sin of.
Dedi kama amena PENDREAM TV ase. Now so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.